This content is intended for educational and informational purposes only. It does not constitute legal advice, and viewers are encouraged to consult qualified legal professionals for any specific legal concerns. Welcome to the Lawyer's Justice, where the courtroom becomes a battlefield of strategy, and justice often hinges not only on facts but on the mastery of legal minds. Today, we unravel one of the most polarizing cases in American legal history, the story of Bernhard Goetz, the man the media named the Subway Vigilante, and how a defense attorney's daring tactics rewrote the script of guilt and innocence in 1980s New York City. In the early 1980s, New York City was gripped by an escalating crime wave that left citizens anxious and vigilant. Subway cars were covered in graffiti, and reports of muggings, robberies, and assaults filled the headlines almost daily. Passengers traveled with their belongings clutched tightly, scanning each carriage with cautious eyes. The police, underfunded and stretched thin, struggled to keep up with the city's surging violence. This was the climate in which Bernhard Goetz, a 37-year-old electronics engineer, found himself moving through daily life. On December 22, 1984, his name would become a national flashpoint. On that cold December day, four teenagers approached Goetz as he sat on a subway train. They were later identified as Troy Canty, Barry Allen, James Ramser, and Darrell Cabey. Accounts differ. The teens claimed they were panhandling for spare change, while Goetz believed they were about to mug him. Fear surged through him. In a matter of seconds, Goetz drew a .38 caliber revolver and fired 5 shots, striking all 4. The train descended into chaos, with passengers screaming and rushing for the doors. Goetz fled the scene, leaving behind a trail of blood and unanswered questions. Days later, he surrendered to police in New Hampshire after a brief escape. The Manhattan District Attorney's Office charged Goetz with attempted murder, assault, reckless endangerment, and criminal possession of a weapon. Prosecutors argued this was no act of self-defense but a cold act of vigilantism. They cited Goetz's own statements, including one where he said, "I wanted to kill them," as evidence of malice. The state relied on New York Penal Law Section 125.25, attempted murder, and Section 120, assault, to frame his actions as intentional and unlawful. Enter Barry Slotnick, a high-profile defense attorney known for his aggressive style and unflinching cross-examinations. Slotnick understood that the heart of this case lay not in cold facts, but in how the jury would feel about fear, crime, and survival in New York City. During voir dire, Slotnick strategically selected jurors who had themselves been victims of crime or lived with the anxiety of subway violence. He knew their personal experiences would make them more receptive to the idea that Goetz acted under genuine fear. Under New York Penal Law Section 35.15, deadly force is justified if one reasonably believes it is necessary to prevent imminent deadly harm. Slotnick emphasized the word reasonable, making the trial about perception, not absolute fact. He portrayed Goetz as an ordinary man cornered by the city's failure to protect him. The prosecution wanted to present the teens as unarmed innocents. Slotnick fought to admit evidence of their prior criminal activity, arguing it went to their credibility. By invoking rules similar to Federal Evidence 609, he convinced the judge that this history was relevant to the jury's assessment of threat. Slotnick also conducted a subtle media campaign, holding press conferences and shaping headlines to cast Goetz as a reluctant citizen pushed too far. One of the most dramatic moments came during the cross-examination of Darrell Cabey, one of the wounded teens. Slotnick led with calm, methodical questions, then introduced prior behavior and inconsistencies. The pressure mounted until Cabey erupted in anger, shouting and gesturing wildly. This outburst played directly into the defense's narrative that Goetz was facing aggression, not harmless requests for change. Under evidence law principles, a hostile or erratic witness often undermines their own credibility. After intense deliberation, the jury acquitted Goetz of attempted murder and assault. He was convicted only on the charge of criminal possession of a firearm. The sentence, 1 year in prison, of which he served 8 months. Public reaction was divided. Some saw justice, others saw injustice dressed as fear. Years later, Darrell Cabey sued Goetz in civil court for damages. Unlike criminal court, where the standard is beyond a reasonable doubt, civil cases rely on a preponderance of evidence. Cabey won a $43 million judgment against Goetz, money he never fully collected. Barry Slotnick's defense became a textbook in high-stakes advocacy. He manipulated the reasonable belief clause to turn a legal standard into a sympathetic story. He leveraged jury psychology, understanding that the law is often applied through the prism of human fear and resentment. And perhaps most strikingly, he waged a trial in both court and public opinion, a tactic now common in high-profile cases. The Goetz case left an enduring imprint on debates over self-defense, race, and vigilantism. It foreshadowed later stand-your-ground controversies, where perception often outweighed provable threat. It also raised the question, do brilliant lawyers win justice, or bend it? Bernhard Goetz walked free on the most serious charges, not because the facts cleared him beyond doubt, but because Barry Slotnick crafted a legal narrative that jurors could inhabit. In that sense, the subway car became more than a crime scene, it became a stage where law, fear, and persuasion collided. And the lawyer? He proved that in the theater of law, strategy can be as decisive as truth.